Welcome to the Alliance Group's presentation of an overview of the FFCRA, the Families First Coronavirus Response Act. My name is Shay Compton, and I'm a Human Resources and Training Consultant with the Alliance Group. I'm going to help break down this law today for you so that you're ready to implement this in your business. What is the FFCRA, and does it apply to your business? The FFCRA applies to businesses with 500 employees or less and is meant to address sick leave and family leave due to the coronavirus. It just passed in March and is effective April 1st, 2020 through December 31st, 2020. There are two acts in this legislation that you need to be aware of. There's the Emergency Paid Sick Leave Act, which provides up to 80 hours of paid sick leave for employees for specified reasons related to COVID-19. There's also the Emergency Family and Medical Leave Expansion Act, which provides 12 weeks of expanded family medical leave due to child care closures from COVID-19. The good news is 100% of qualified paid emergency sick leave and qualified paid FMLA leave wages are fully reimbursable through tax credits. Let's start with the Emergency Paid Sick Leave Act. The Emergency Paid Sick Leave Act requires employers to provide up to 80 hours of paid sick time for full-time employees, and for part-time employees, the average amount of hours that they would have worked in a 2-week period due to specific COVID-19 related reasons. This is regardless of their tenure with the company and is in addition to any current PTO policies that you may already have in place. The COVID-19 related reasons are: the employee is subject to a government-ordered quarantine or isolation order for COVID-19. 2, the employee is advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. Number 3, the employee is experiencing symptoms of COVID-19 and seeking a medical diagnosis. Number 4, the employee is caring for an individual who is subject to number 1 or number 2 above. Number 5, the employee is caring for his or her son or daughter if the child's school or place of care is closed or unavailable due to COVID-19 precautions. And number 6, the employee is experiencing any other substantially similar condition specified by the Secretary of Health and Human Services in consultation with the Secretary of the Treasury and the Secretary of Labor. The pay requirements for the emergency sick leave: if it is for a quarantine or isolation order, advice from a healthcare provider to self-quarantine, or experiencing symptoms of COVID-19 and seeking a medical diagnosis, then the employee is paid their regular rate of pay up to a cap of $511 per day, or $5,110 total. If it is for caring for an individual subject to a quarantine or isolation order, or who has been advised by a healthcare provider to self-quarantine, caring for their own child whose school or place of care is closed or unavailable due to COVID-19, or experiencing any other substantially similar condition specified by the Secretary of Health and Human Services, then the pay rate would be 2/3 of the regular rate of pay, up to $200 a day, or $2,000 total. Emergency Family and Medical Leave Expansion Act expands current FMLA leave to employees who can't work or telework because their minor child school or child care services closed due to a COVID-19 emergency declared by federal, state, or a local authority. Eligible employees work for a private sector employer with less than 500 employees and have been on the payroll for at least 30 calendar days. The leave can be used intermittently if both the employer and the employee agree to it. Let's say that an employee is only able to telework 20 hours per week now because of needing to care for their children due to COVID-19 related reasons. The employer can allow the employee to work 20 hours per week on telework and 20 hours of FMLA leave to compensate the other 20 hours that they are unable to work. The first 10 days of leave under the FMLA are unpaid. However, employees may elect to substitute available PTO during this time. They can also use emergency paid sick leave during this time as well. After the 10 days, employers must pay 2/3 of the employee's regular rate of pay, as defined by the FLSA, based on the number of hours the employee would otherwise have been scheduled to work. If you have questions about what your employee's regular rate of pay is, like if they receive bonuses, tips, anything supplemental like that, please contact your Alliance Group payroll representative or the HR team for help and guidance with calculating your employee's regular rate of pay. The benefits of the EFMLA are capped at $200 per day or $10,000 total. For example, let's say Sonia normally works 40 hours per week and earns $20 per hour. 40 times $20 per hour equals $800 times 66.67%, which is 2/3, equals $533.36 in gross earnings. Rudy, let's say that he's a part-time employee and he normally works 20 hours a week on average, and he earns $10 per hour. You would take his 20 hours a week times $10 an hour equals $200 times 66.67%. His gross earnings would be 133.34 of FMLA leave. Some exceptions are the EFMLA does not apply to federal government employees who are covered by Title II of FMLA. However, the emergency sick leave does. Employees working for a healthcare provider or emergency responder can be excluded from the paid sick leave and EFMLA leave by his or her employer. There are some exceptions for small businesses. An employer with fewer than 50 employees is exempt when offering the leave would jeopardize the viability of the small business as a going concern. A small business may claim this exemption if an authorized officer of the business has determined that the paid leave would result in the small business's expenses and financial obligations exceeding available business revenues and cause the small business to cease operating at minimal capacity. The absence of the employee or employees requesting paid leave would entail a substantial risk to the financial health or operational capabilities of the small business because of their specialized skills, knowledge of the business, or responsibilities, or there are not sufficient workers who are able, willing, and qualified and who will be available at the time and place needed to perform the labor or services provided by the employee or employees requesting leave, and these labor or services are needed for the business to operate at a minimal capacity. We recommend that if you are going to claim the small business exemption, that you reach out to us or qualified legal counsel. Since there are tax credits available, you would want to make sure that this does truly apply to you. Employers with less than 25 employees are exempt from the obligation to reinstate an employee at the end of his or her leave if the employee's position has been eliminated due to economic conditions or other changes in operating conditions of the employer caused by COVID-19, and the employer is unable to reinstate the employee to an equivalent position. The FFCRA also included requirements for group health insurance plans. Group health plans must provide coverage without any cost-sharing requirements such as deductibles, co-payments, and co-insurance, or prior authorization or other medical management requirements for the costs of a test to detect or diagnose the virus that causes COVID-19, or healthcare provider visits, including telehealth visits, urgent care, and emergency room visits that result in an order for or an administration of a test to detect or diagnose the virus that causes COVID-19. As I mentioned previously, there's tax credits for paid sick leave and paid FMLA leave. Businesses can receive a tax credit each calendar quarter for 100% of the qualified sick leave wages and qualified family leave wages paid by an employer during the calendar quarter, including some costs associated with providing and maintaining a group health plan during such paid leaves. Employers can take an immediate tax credit by retaining the amount of payroll taxes equal to the amount of qualifying leave they paid, rather than deposit them with the IRS. Payroll taxes that can be retained are withheld federal income taxes, the employee's share of Social Security and Medicare taxes, and the employer's share of Social Security and Medicare taxes with respect to all employees. If the paid leave is greater than the amount of payroll taxes owed, employers can file a request for a refund from the IRS. The IRS is expecting that process will take 2 weeks or less to process. It will be important for the business to keep good record-keeping documentation and certification for any paid leave because businesses who grant leave without obtaining and keeping appropriate documentation may not be eligible to receive a tax credit. Documentation that employers may require employees to provide include the following: the source of any quarantine or isolation order, the name of the healthcare provider who has advised the employee to self-quarantine, a notice of school closure or lack of childcare. The documentation should include the employee's name, the reason for requested leave, a statement that the employee is unable to work or telework for that reason, and the dates for which leave is requested. You may be wondering how this applies if your business has went through a closure, had to furlough employees, or had to reduce an employee's hours. If an employer closes a work site or furloughs employees before April 1st, the employees are not eligible for paid leave under the FFCRA. However, if the employee later resumes work, then they would qualify thereafter as warranted. If an employer closes the work site while an employee is on FFCRA leave, the employee must be paid for any leave before the work site was closed. However, they're no longer entitled to leave after the work site closes. Any employees who have had their hours reduced because the employer does not have work for them to perform do not qualify for paid leave for the hours that the employee is no longer scheduled to work. They still qualify, though, if they can't work for a qualified COVID-19 related reason, and that is the reason for the employee deciding on their own to reduce their hours. How does the emergency paid leave interact with any other pre-existing benefits or sick leave that the employer already offers? An employer cannot force an employee to take the pre-existing PTO or paid leave policies prior to taking the FFCRA paid leave. An employer and employee may agree to simultaneous use of the employer's paid leave policy to supplement with the FFCRA paid leave. So if they want to allow the employee to take that 1/3 pay reduction, if they want to use their PTO or some other paid form of leave to supplement the FFCRA paid leave, they can do that, as long as the employer agrees to that. How do the emergency leaves interact with traditional FMLA? If the employee has already taken, let's say, 12 weeks of FMLA leave, they can still use emergency paid sick leave because it's not a form of FMLA and may be taken regardless of how much leave has been taken under FMLA. However, with traditional FMLA and the emergency FMLA, if an employee has already taken 12 weeks of FMLA leave, the traditional FMLA leave, they're not entitled to an additional 12 weeks of emergency paid leave. They're only entitled to how much leave is left. So let's say they've taken 6 weeks of traditional FMLA, then they would have 6 weeks left of EFMLA. In summary, employers who have 500 employees or less and are not subject to any exceptions or exemptions must offer qualified employees up to 80 hours of paid sick leave and 12 weeks of expanded family medical leave for specified COVID-19 reasons effective April 1st, 2020. Group health plans are required to cover certain health insurance costs related to COVID-19. Businesses qualify for 100% refundable tax credits for the paid leave they provide under the FFCRA, as long as sufficient documentation is maintained and they follow IRS guidance. If your business has made the decision to close down, lay off, furlough employees, or reduce employee hours, then those employees are no longer eligible for leave or for the difference in leave for the reduced hours. 12 weeks of EFMLA is not in addition to 12 weeks of FMLA. The employee is only entitled to take as much EFMLA as they have remaining of traditional FMLA leave if they have already taken FMLA leave prior to April 1st, 2020. So what do you do now? Here are some action items. You'll want to post the required FFCRA poster in a conspicuous location at your worksite where employees can view it and make it available to remote employees. Create a policy or utilize the tag sample policy that's on our website. We also have the FFCRA poster on our website as well. Utilize the Alliance Group HR team as a resource for any questions and to assist with the leave implementation and tracking. Obtain appropriate documentation for FFCRA leave and have employees complete the appropriate leave paperwork from our website. Thanks for listening, and on behalf of the Alliance Group, thank you for your business. We hope you found this video helpful. If you have additional questions, don't hesitate to contact us at 402-344-7700 or email us at hr@alliance-peo.com.